Call David Clendon.
Mr Speaker, I'm pleased to take the call on this, and picking up from the final comments of the previous speaker, I'd like to begin by talking about the process. It's been pointed out that we have a 9-day deadline before us, and that's an extraordinary thing when one considers we are talking about an amendment to substantive legislation that was enacted in 2005, some 7 years ago. This government has had complete control of the legislative program, of the House program, for some 3.5 years. And we hear today from the Leader of the House that next week we will be extended hours, potentially going into urgency. And one of the bills that we must use these longer hours for is this Prisoners and Victim Bill. That's an extraordinary failure of political management, of legislative management, after 7-odd years, to have to rely on extended hours or potentially urgency to deal with a deadline that was flagged so long ago. It is a remarkable failure. Well, I'm told I'm a confused member. In fact, I invite the member to do the sums. 12 minus 5 does equal 7, always has. The fact is that we are running up against a deadline, and it is a failure of political management, and that is undeniable. The process further has been truncated. This bill was tabled a couple of months ago at the beginning of a parliamentary recess. Very few members of civil society, few of the interested NGOs, few of the organisations who would take an interest in this sort of bill had any idea it was coming forward. The government used its numbers to force a truncated select committee process. Barely 6 weeks was allowed for the select committee process, and it's only through change in standing orders we had any opportunity even to debate that. And I'm pleased that the Labor and Mana parties supported the Greens in opposing that motion to have such an extraordinarily short select committee process. It's a very undemocratic, it's a very sloppy way to progress legislation, and the government should be ashamed of that, a failure to manage this better. So the substantive legislation we are changing was very well described by Mr Cheval, who in his first reading speech described it as an experimental piece of legislation. As he did explain earlier, I won't repeat that in any detail, but it did come from the behaviour management regime, the systematic abuse and torture of inmates in one of our largest prisons. The climate of the day saw significant objection to the fact that despite these prisoners having proven a case of abuse and torture, that there was some disquiet about them receiving the monetary compensation, and this legislation we're amending was the result of that. The reality is that at the time it was supported by the Greens, and I suspect in part by other parties, because it was clearly flagged there would be a substantive review, and that for that reason there was a deadline, a sunset clause in the legislation. One of the things promised at the time was an independent prison inspectorate, which in fact we never did get. It's true that the Ombudsman's office do have dedicated officers who do a very good job of monitoring prisons, dealing with prisoner complaints. That's an issue we can return to. The reality is there has been ample time to review the situation, the continuance of this legislation, and it clearly has been flagged by the government that is their intention to embed this legislation. It almost preempts, it indicates that the government is expecting that there will be ongoing examples of abuse of prisoners in our prisoners while they're in custody, and that we need to ensure that they cannot receive any sort of compensation, any sort of monetary compensation in the event of such abuse occurring. That's an extraordinary assumption to make, given that corrections has changed. We have seen reform of the correction system. There's a great deal yet to do, it must be said, but I don't think that the situation that arose in the early 2000s would be tolerated today, that it would be possible. If there is abuse of inmates, then it should be those responsible should be taken to task, and we would argue that inmates should continue to be eligible for some compensation for that. We are told, and the Minister in her first reading informed us, that the need for this temporary legislation was pressing, because otherwise, she said, there would be a clear incentive for potential claimants to file claims during this window of opportunity, which she said would defeat the purpose of the current regime. She went on to say the new bill will prevent the unfair window of opportunity from occurring that would disadvantage victims of crime. That is an extraordinarily narrow interpretation of the notion of fairness. What about the fairness for the people who were indeed originally denied their human rights, who were abused in custody, who were deemed to have suffered torture? What about their rights? They too were victims of crime, and their right to be compensated was taken away from them. The continuance of this experimental legislation, well described, embedding the regime of zero compensation, because that is what it will do. It's an admission that this government does expect further abuse and misbehaviour within the correction system, and I think the Corrections Minister should be quite concerned about that. The point's been very well made by the previous speaker that the regulatory impact statement was clearly done in considerable haste. And indeed, the submission from the New Zealand Law Society highlighted that there are probably fairly substantial errors of fact in that regulatory impact statement. No disrespect to the officials involved, it's simply that there was not adequate time given them to do a good job, which is what we normally expect and see from them. The Law Society also has pointed out that the original legislation was never subject to a Bill of Rights, a Section 7 report, and indeed nor has this continuance legislation been subject to that. That is simply an extension of a regime which was always intended to expire. It should be allowed to expire. It has served whatever useful purpose it may have done. There is clearly a contingent liability on this government, on the government of the day, if indeed new claims were to emerge from the period of the early 2000s. That is a reality, and the government should basically front up and wear that cost, rather than continue to embed, to continue with what is a very unfortunate piece of legislation. Excuse me. As I said, this bill perpetuates two very perverse incentives. It could, in a very perverse way, actively encourage or almost give licence for the abuse of inmates, given that it's most unlikely that those inmates would see particular value in making claims against the state for any abuse that they suffered in prison. The second is that it seems perverse that anybody should benefit from the abuse or torture or mistreatment of prisoners while they're inmates of the state. Our international obligations have always been compromised by this legislation. It's true that the Article 8 of the Universal Declaration of Human Rights guarantees, and I quote, the right to an effective remedy, and Article 2 of the International Covenant on Civil and Political Rights does something similar. It demands that people whose human rights have been compromised ought to be entitled to an effective remedy from the state who is responsible for that. It cannot be accepted at any level that absolute denial of any compensation or possibility of any monetary compensation coming to a person whose human rights were compromised could be seen as meeting the international obligations that New Zealand has accepted as signatory to those international agreements and documents, conventions. This was always well, in 2000, when first passed, it was a very marginal piece of legislation. The Greens only supported it originally on the understanding there would be a rigorous and timely review and the installation of an independent prison inspectorate. None of that has occurred. This is a very poor process for a very poor piece of legislation we will continue to oppose.
Dr. Cam Calder.
Mr. Speaker, on this side of the House, we make no apologies for focusing the justice system on the rights